former governor of Delta State, James Ibori, facing a risk of a fresh 10-year jail term over money he is expected to pay following his conviction in a UK court in 2012. The court is set to order the seizure of more than £100 million from the former governor. The development comes about 6 years after Ibori returned to Nigeria following a prison sentence he served for money laundering and fraud charges. The British authorities had indicted the former governor for stealing public funds and laundering them through UK banks and properties. However, the trial on confiscation proceedings against Ibori began in February 2017. Judge David Tomlinson at Southwark Crown Court has made factual findings regarding the amount of money linked to Ibori. During a hearing on Thursday, the prosecution and the defense presented their arguments on how the confiscation figure should be calculated based on the judge's findings. Ibori, as you do know, who returned to Nigeria in 2017, served his sentence but did not attend the hearing. The prosecution lawyer, Jonathan Kinnear, told the court that the total amount that should be confiscated from Ibori was £101.5 million. Meanwhile, the Anambra State Police Command has confirmed that a couple, their 2 children and others died from suspected generator fumes in their residence at Inkweli Ezunaka near Onitsha. The Onitsha-based trader, his wife, 2 children, mother-in-law and newly arrived apprentice on Wednesday reportedly died after inhaling poisonous fumes from the generator. VOP News gathered that the man's wife had just been delivered of a baby, and to give the wife a surprise gift, the man quickly arranged for the family to move to their new house. Sources in the area said it was the family's first night in their new residence, adding that only the 4-day-old baby survived. The source said the incident was made known when a friend who was supposed to join them in the celebration that night but couldn't meet up went to the deceased house, only to discover that the doors were locked with the generator still on. Elsewhere, authorities at the University of Lagos, Unilag, Akoka, Lagos have increased fees for undergraduate students. This was contained in a statement dated July 20, 2023 by the Senior Staff Association of Nigerian Universities, SANU, Unilag branch, following a meeting with the top management staff. According to SANU, the VC, Professor Ogunshola, met with representatives of the 3 non-academic staff unions on Thursday, July 20th, to discuss issues concerning members' welfare. The union in the statement said the VC stated that fees would be increased for Unilag undergraduate students. According to the statement, a SANU representative at the meeting, Razaki Yusuf, asked for rebate for staff members with children in the university. But the VC said the new charges were set nationally and could not be modified for specific categories of students. Ogunshola, however, gave the option of staff paying in installments, but with a condition to pay up 1 month before final exams. Now, in court-related matters, the suspended governor of the Central Bank of Nigeria, Emefiele, is scheduled to make a court appearance on July 25 at the Lagos Division of the Federal High Court. Emefiele has been detained by the Department of State Services following allegations leveled against him. He is due to enter his plea before Justice Nicholas Owebo. Recall that on June 10, DSS operatives visited Emefiele's residence in Ikoyi, Lagos, a day after his suspension as CBN governor by President Bola Ahmed Tinubu. In response to the alleged contempt, the lawyers filed a notice of consequences of disobedience to a court order and a request to commit the alleged contemner to prison. Form 49 at the High Court of the Federal Capital Territory, FCT, Abuja. They also called for the dismissal of DSS Director General Mr. Yusuf Bichi after the agency referred to them as charge and bail lawyers and sympathizers of the indigenous people of Biafra, IPOB, on Twitter. Now, in another development, still on court-related matters, the Labour Party and its presidential candidate Peter Obi have dismissed a written address by President Bola Ahmed Tinubu regarding the February 25 presidential elections. They label the president's response as a sign of desperation taken too far. Recall that in the address, the president's representatives, led by Wale Olanipeku, challenged the claims made by Obi's witnesses, including Clarita Oga, a supposed cloud engineer at Amazon. They warned the Presidential Election Petition Court that a misinterpretation of the law related to lawful votes cast in the Federal Capital Territory, Abuja, could lead to chaos and anarchy. The petitioners, in response, suggested that the only path to anarchy is the truncation of the rule of law. Obi's lead counsel, Levi Uzuku, filed a final written address stating, and I quote, "This is a cheap, misguided, and destructive blackmail clearly intended to target the country's judicial and constitution. It also aims at cannibalizing our democracy." Uzuku further condemned the president's address, stating, "Desperation taken too far can be extremely dangerous. Let the second and third respondents, Tinubu and Shetima, know that where the rule of law is trampled upon or truncated, anarchy reigns supreme." The court has given both the petitioners and the respondents a set number of days to file their written addresses, with the respondents given additional time to reply on point of law. However, the PDP and the Labour Party have eventually tendered their written address, and it is actually quite a long one. In order for us to actually look into the critical issues submitted in the final written address, I have via the telephone Barrister Eze Eluche, who is a legal practitioner, a political and social affairs commentator. Barrister Eze Eluche, good evening and welcome to the World News at 6 right here on VOP 90.3 FM.
Good evening, and thank you for having me in your studio.
Thank you so much, Barrister Ezra. I really do appreciate it. Okay, so the Labour Party has tendered their final written address, and this time around, they said that the APC should be careful in the way they talk about, they relay the situation at the Election Petition Tribunal, stating that whatever they say could be a cannibalization of the Constitution and truncating the rule of law, which could eventually lead to chaos and anarchy. Have you looked at the final written address of the Labour Party and the PDP, Barrister?
Yes, I have. And then, they are expected. What the address is, the final written address,
okay,
is a summation, a summary of what the presentation during the trial was.
Yes.
And a response to whatever the respondent filed in their pleading. So that is how it goes in court.
All right, so
that the petitioners will file their own draft, and that's what both the Labour Party and the PDP have done today.
Now, based on what the Labour Party tendered, they refer to critical issues which we've been talking about right here on a Voice of the People 90.3 FM on our news bulletins. They mentioned the $460,000 against him, Bola Tinubu, which represents proceeds of narcotics trafficking, money laundering. They also mentioned the pursuant to the mandatory provisions of the Electoral Act 2022 and the subsidiary legislations made thereunder, regulations and guidelines for the conduct of general elections 2022, where they talked about INEC, who said that is by this, INEC represented and provided that it would use the bimodal voter accreditation system for the accreditation of voters in the polling units, and eventual upload, which proves that the INEC result viewing portal was supposed to be active, and that did not work. These were part of the things they tendered as their evidences in order to summarize, what they claim that there were the infractions that were witnessed during the elections. They also stated that INEC vigorously campaigned that the use of technology in the electoral process, including the upload, transmission of the results of the election in real time using beavers from the polling unit to the Arab, will ensure the integrity and credibility of election results in Nigeria. So why is, again, based on that particular detail, they said, why is INEC responding in such a manner like they did not give Nigerians the assurance that the bimodal voter accreditation system will work and that the Arab portal was a strong updated means to ensure the objectivity and transparency of the elections. Now, in INEC's response, if you had listened to the World News at 12 today, INEC literally said that why did the Labour Party not present, the original results if they claim that INEC truncated? If they claim that INEC truncated their votes by uploading blurry results, that each of the polling units, that is the 18,088 polling units where Labour Party claimed that, their results were deducted, their votes were deducted, why did the party agents in those polling units not present the actual results? So they literally said that the claim of Labour Party is unsubstantiated. If you have critically read the final address of the Labour Party, based on that and what INEC had surmised in their own written address, what would you say to that? What's your reaction to the development?
Well, like I said earlier, the final written address by both the respondent and the petitioners is a summation and a summary of what we have stated already in court and to respond to legal issues raised by each side. Mm-hmm. So we already know what these are, and then the people already know it. The very worrisome part of this process is that these very senior lawyers on both sides deeming it fit to come into the public domain to canvass for whatsoever. The matters are already filed before the court, and it is for others who are not really part of the process, of the legal process, to make commentary. When the same lawyers who have already submitted and filed these reports in court now come out and start making judicial comments, it gives a very serious kind of worry. And it's also reflective of how serious this particular litigation is.
Okay.
Because they all know the number of Nigerians, that most Nigerians are very keenly interested in this issue. And that is why they're perhaps trying to also let the public understand what is going on. So the responses by the INEC and the APC is rather worrisome and troubling. INEC, that is the official custodian of the results, is saying, why didn't the parties, the petitioners, produce their own copies of these results? It's disgraceful. The official record of results are the ones in the custody of INEC. So if due to their maladministration or their not being serious about what they are doing, they had to do a lot of mutilation, and these things have been defaced. It is ridiculous that INEC itself, without shame, without asking the political parties where are their own results, knowing too well that it's the INEC results that are the original and official results that can be tendered and used in the litigation process. This same INEC refused to produce documents that the parties subpoenaed them, that the court even ordered them to produce. So in the face of such refusal, INEC is actually being very disgraceful and shameless.
Barrister Eze,
Yes.
I want to mention some key points that were raised in this final address by the Labour Party, which of course is basically the final address of Peter Obi. So they said something which some of us could actually have to logically consider. They said the exhibits, right? 4 boxes of blood documents uploaded on the ARA portal by the first respondent. The first respondent this time around is the APC, right?
Yes.
And falsely represented as Form EC8A. The blood 4 documents, blurred, they were blurry, right? Uploaded. And they were falsely documented as Forms EC8A, were tendered by PW4, that is exhibits. They mentioned all the exhibits. They gave them several titles. They said they are blood copies of documents certified by the first responder. So these blurry documents were being certified by the first responder, this time around APC, as purported Forms EC8A, EC8B, EC40G, and EC60E, which were given to the petitioners as certified copies. They were given to the petitioners as certified copies of the original document in possession of the first respondent under sections 102, 104, and 105 of the Evidence Act. They said these certified copies of purported original copies of election results referred to the above were in some cases were blank A4 papers and pictures of unknown persons. With this submission tendered, how can INEC determine who won with some of these, uploaded on the ARA portal? That's one question that, they're asking in their final address to the judges at the Election Petition Tribunal. Now, they said that apart from the blatant refusal to comply with the mandatory requirements of the law, the certified copies of the result of the election given to the petitioners by the first respondent manifestly show that the purported Forms EC8As in several polling units were affected by mutilations, cancellations, alterations, and outright swapping of votes in favor of the second to the fourth respondents and against the petitioners. Please, I need you to help me clarify what this means. They seem bulky. They're actually too wordy. But it's important that when we're talking about these things, we're evidently putting it out there so it doesn't seem as if anybody's concocting any information. What's your take on this particular narrative or final submission of Labour Party to INEC's final written address, including that of the APC?
No, Lisa, you see, you're burdening your listeners with so much technical details.
That's basically why I'm asking you, so you can help us break it down. So they are the facts on the sheet there.
In a short form, it was INEC that upload documents to the IRS portal.
Okay.
And it was INEC, this same INEC that certified blood documents for the political parties to take and present in court. So the issue is it is very wrong and mischievous of that same INEC, which uploaded blood documents to IREC portal and gave and certified the document for political parties to turn around and now ask parties why didn't they produce their own copies. It showed errant mischief on the part of INEC. And I will hope that the court will, beyond even giving a judgment to the petition, also place sanctions on the INEC officials who participated in this fraud. Because it's embarrassing that a public institution funded by public funds can be involved in such ridiculous fraud as deliberately satisfying blood documents as its own result. So the reality is this election is like none Nigerians have had before. In previous times, nobody get to know the details of the criminality that the INEC officials have participated in. But in this case, we saw it from ground. INEC was discountenancing and denying its own document,
yes,
which is satisfied. It was ridiculous. The INEC chairman, deliberately knowing the criminality he had perpetrated, shied away from even coming to court, despite several attempts to summon him. So it is unfortunate if the court allow such brazen criminality to go unpunished, because it can only mean that next time the same INEC officials will think that they can get away with crimes and repeat the sentence. The court will use their powers to set examples in this case. Like I said earlier, the parties have only merely reiterated what they had canvassed.
Barrister Ezra, are you using an earpiece? Because you sound muffled a little bit. I really need to clearly hear your explanation on some of this technical stuff. On
are you with me now?
Yes, I can. Now? Yes, I can hear you now. Go ahead.
Yes. Good. So the fact remains that the fundamental aspects of their petitions of both the Labour Party, the PDP, and the Allied People's Movement cannot be controverted because they are realities and facts which INEC has.
All right.
One of them is the fact that the APC vice presidential candidate was improperly nominated. And it had been improperly nominated, it goes to the roots of the APC ticket. The other issues are that of 25% in Abuja, and the fact that $460,000 was forfeited for crimes bordering on fraud and dishonesty. So these are fundamental. That cannot be, no matter what language the INEC tries to do, they cannot contravene these facts for now.
All right.
We will only urge that the lawyers will restrict their public utterances. The facts are already known, and the courts, for goodness sake, every party has submitted their final written addresses. I do not see why this court cannot determine this matter within the next 1 to 2 weeks. Delay is dangerous. The earlier these decisions are made, is better for the polity, and people will stop raising dust and mayhem where there is none. The court should do Nigerians a service and give it as soon as possible.
Well, there are tendencies that by August, possibly we should hear, but, they said about 180 days. We should elapse sometime in either ending August or September. Barrister Ezra, so the PDP too also tendered their final written address, right, in reaction to what INEC had submitted and what APC had also submitted. They said that the ruling party was favored by INEC, basically, from what I can see here. And they stated that INEC manipulated the technologies earlier put in place to ensure transparency and wrongfully returned the said second respondent, that is the APC's presidential candidate in person of President Bola Ahmed Tinubu, as winner at about 4 a.m. on the 1st of March. At the time, the first respondent admitted that substantial percentage of the results had not been transmitted to the collation system for verification as required by law. They also said that under the cover of the so-called technical glitch is excuse, which the first respondent never explained, the results were deliberately manipulated through suppression and discounting of the votes of the first petitioner and inflation of the votes of the second respondent. This deliberate bypass of the use of the prescribed verification technology was nationwide and substantially flawed the return of the second respondent. So you said again that the first respondent is APC. It sounds like the first respondent is INEC. Then they also said that the second respondent is constitutionally disabled from contesting for the office of president. So I think the second respondent is President Bola Ahmed Tinubu. So they said that in light of the criminal forfeiture judgment against him for the sum of $460,000, they also stated again that the collation of results in the said election was to be technologically based. However, in order to suppress the actual results of the election, applied for leave of the Honorable Court to reconfigure the BVAS machines used for the election with an undertaking to preserve the data used in the presidential election. What's your take on the response of the PDP to what transpired on February 25, based on the elections after they were collated? The results, rather.
Thank you very much.
Mm-hmm.
The INEC is not free to do whatever it wants with the results. There are procedures laid down by the Electoral Act and by INEC regulations.
Okay.
A very fundamental part of it was that where any issues crop up during coalition,
okay,
INEC is supposed to look into those issues, make a final finding from those issues before even proceeding to announce results. During the process of coalition of results at the National Coalition Center, the PDP agents voiced out their concerns with specific states. The INEC chairman promised to look into those things before the final results will be announced. INEC never looked into those issues or concerns of the PDP and proceeded to announce the results and declare Mr. Tinubu president-elect by around 4 a.m. in the wee hours of the night. So without any doubt, the procedures for even coalition and announcement of results was not complied with. And if you don't comply with the laws, you have faulted the laws, and whatever you've done becomes unlawful. That and several other aspects of the entire process of the election are fought in illegality. Like the one you mentioned, which has been severally repeated. The issue of the qualification of Mr. Tinubu and his vice.
Yes.
The Abuja issue, the fact that the APC does not even have a lawful candidate in the presidential election. So these are germane issues that once you look at it, and all these manners of noise and abuse that the APC and their lawyers are running up and down, it's of no moment. We should allow the courts to rule on this because the facts are very clear. And once the court rules on it, they just not know what next to do or how to take our judicial system. But errors were made. Even if the APC plan to rig this process, they make fundamental errors which cannot be corrected now. So the facts are clear. Let the court expedite the decision. And let me say, when the law says you have 180 days to make the judgment, it does not mean you must wait till 180 days.
Okay.
It means that between 1 and 180 days, you can do that process. So if, as of today, all the parties have submitted their written addresses, the justices who have presented over this matter can, if they determine to, within the next 2 weeks, write their judgment and save Nigerians the unnecessary stress of the prolonged doubt as to what happened in this election tribunal. The earlier, the better. So that one of them will not fall sick or die or resign.
Okay.
Because if any of those things happen, if any of these judges should fall sick or die or resign, it means that the entire election petition process has been rubbish.
Wow.
Rubbish in the sense that there is a period when this tribunal must sit. And having consumed more than half of that period, no tribunal can restart this process.
Okay.
So the earlier the tribunal delivers judgment, is better for everybody in this country.
All right.
So that nothing will happen to this judgment and we can move on in one place in this country.
All right, thank you so much, Barrister Eze Oliche. Unfortunately, we need to round off the world news at 6, but I appreciate your contribution and explaining some of the technicalities, like you mentioned, on the final written addresses of the Labour Party and the PDP at the Election Petition Tribunal. Thank you.
Thank you very much for having me.
All right. Bye-bye. Now, to wrap up the world news at 6, here again are the top stories. You heard that Ibori faces first 10-year jail term, £100 million seizure in the UK. Also, 7 die, 4-day-old baby survives generator fume in Anambra State. Unilag increases tuition fees. CBN Governor Emefiele is set to appear in court. Peter Obi's lawyers blows hot at Tinubu. And that is a wrap on the world news at 6 right here on Voice of the People 90.3 FM. My name is Esther Wachuku. Good evening and thank you for listening.
Are you aware that Iruka Online Limited installed and designed a 100,000 capacity church building? Oh yeah, we are the sole distributors of global leading brands all over the world, such as Wafday Line Array, speakers and digital amplifiers, Preseno's digital mixers and studio equipment, Coswell workstations and keyboards, Fender guitars, Mapex drums, Ashdown bass combos, just to mention but a few. We offer